Good morning and welcome to PV Legal's daily newsletter. Here's a situation that is playing out in thousands of GST cases across India right now. You buy goods from a registered supplier, you pay GST. The invoice is reflected in your GST R2B. You claim input tax credit. And then the tax department comes after you because your supplier failed to deposit the tax with the government. Now here's the critical question. Is that legal? Two of India's high courts have answered that question in a span of 3 months. And they have reached completely opposite conclusions. Today we examine both judgments and tell you exactly where this battle is headed. The first judgment is from the Gujarat High Court in Maruti Enterprise versus Union of India, decided on the 1st of May 2026. This was a batch of over 60 petitions, all challenging the constitutional validity of Section 16(2)(c) of the CGST Act. The second judgment, delivered just 3 months earlier, is from the Karnataka High Court in Messrs. Instacart Services Private Limited versus Union of India, decided on the 9th of February 2026. Same provision, same constitutional challenge, diametrically opposite outcome. Section 16(2)(c) of the CGST Act says that a purchasing dealer cannot claim ITC unless the supplier has actually paid the tax to the government. The purchasing dealers in both cases had done everything right. Valid invoices, goods received, ITC reflected in GST R2B, returns filed. But their suppliers defaulted on tax payment. The revenue denied ITC and initiated recovery against the buyers. The buyer's argument was simple and powerful. We have no access to the supplier's GST R3B. We cannot compel the supplier to pay. We cannot verify in real time whether the tax has been deposited. Penalizing us for someone else's default is manifestly arbitrary and violates the Constitution. Both courts were asked to answer the same 3 questions. First, is Section 16(2)(c) unconstitutional under Articles 14, 19, 265 and 300A? Second, should it be read down to protect bona fide purchasers? Third, do Section 41(2) and Rule 37A provide sufficient safeguards, making reading down unnecessary? Karnataka said yes to reading down, joining the Gujarat High Court, the Tripura High Court, and the Delhi High Court, all of which had held that a bona fide purchasing dealer cannot be penalized. Critically, the Supreme Court had dismissed SLPs against the Guwahati and Delhi judgments, lending powerful weight to the reading down camp. Gujarat said no, holding that the GST regime's destination-based architecture, the cross-state fiscal implications of Section 53 and the safeguards together make the provision sound. The axis of disagreement is sharp and important. Karnataka and its allied courts emphasize the rights of the innocent buyer, the impossibility of compliance, the principle against vicarious liability, and the European Court of Justice's standard that ITC can only be denied if the buyer knew of fraud. Gujarat emphasizes the systemic integrity of the GST chain. If suppliers default and buyers still get credit, the originating state must transfer funds it never received. Both arguments have real weight. That is precisely why this conflict cannot be resolved by high courts alone. From a practitioner's perspective, the immediate takeaway is this: wherever you are litigating, insist on the Axel Kittel standard, assert the Karnataka judgment, and demand that revenue pursue the defaulting supplier first, and add indemnity clauses in your supplier contracts today. The Supreme Court must now resolve this. Until it does, the outcome of your ITC dispute may depend on which court has jurisdiction. That is not acceptable in a unified national tax system. For the full legal analysis of both judgments, subscribe to PV Legal's daily newsletter. This is your host signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Thank you for watching. Good day.